say hello a lot of times. So if you missed it before, we will have thumb drives over at Labs all afternoon with betas of all the cool new stuff we just saw. And also, anybody in a blue shirt can help you if for any reason you feel unsafe or anything weird is going on. Just find somebody. I'd like to introduce you to our next speaker. He is an iOS dev attorney from Raleigh, North Carolina. He is a tech enthusiast. He loves soccer, the Arsenal specifically. May I present Jonathan Rhyne.
Hey, how you guys doing? Can everybody hear me? Yep. All right, awesome. Well, as you guys know, they decided to put an attorney up here in front of you guys first instead of anything else. So I thought I would start out with a nice little programmer joke. All right, how many software developers does it take to screw in a light bulb? None. That's a hardware problem. All right, so I'm Jonathan Rhyne. As she said, I'm an iOS dev attorney. I've been doing this for about 5 years. I represent individual developers as well as some of the bigger companies. You guys probably know a couple of my clients, and you probably don't know some of my clients. So after AltConf, I gave a talk there. I realized that I have to start off every talk with an obligatory Steve Jobs picture. So we'll start off. My name of the talk is Debugging the Contract. And there's my obligatory Steve Jobs picture. Yay! All right, and then also I learned after AltConf that as well as starting my talk off with the obligatory Steve Jobs picture, I have to start off with the Steve Jobs quote. So here we go. This is one of my favorite quotes from Steve Jobs. He says, "There's been one of my mantras, focus and simplicity. Simple can be harder than complex. You have to work hard to get your thinking clean, to make it simple." And of course, again, I told you I'm an attorney, and what does an attorney do to anything it sees? You got to mark it up a little bit, right? Yeah, so we're going to knock out thinking there and add some stuff. So really, you have to work hard to get your contract clean to make it simple. And so that's what I want to talk to you guys today about. How can we get that contract? What's being put together in front of you? What are some of the major clauses that are negotiated? And things that you guys as developers should be aware of, and even companies in this space. To start out, some of the major clauses negotiated are Dickard terms, intellectual property, confidentiality, restricted covenants, warranties, indemnification. I'm sure some of these look familiar to you guys. You guys know of them, or you've probably heard, indemnification, patent trolls, like things like that. So I wanted to take each one of these and kind of go over it and, give you guys a little bit of information about it. So Dickard terms, that's a great old English word a lot of people, don't understand. I don't really know what it really means, but what am I talking about when I say Dickard terms? I'm talking about price, I'm talking about term, I'm talking about deliverables, etc. These are the things like, is it an hourly contract? Is it a milestones contract? These are things that are commonly everybody thinks about that are actually negotiated in the contract, but things that you guys should pay close attention to, because depending on how the contract is set up should depend a lot on price, for instance. Should depend on how much IP you're giving away. Is it a work for hire contract, or is this something where I'm just giving licenses out? These type of things matter because in any contract, it's ultimately risk versus reward, and everything is negotiable down to the bare bones stuff is the Dickard terms, down to every single thing we're talking about. So to go on there, intellectual property is probably the biggest thing that's actually negotiated in a contract, or something that I think you guys should pay particular interest to because it can ultimately put you out of business. It can ultimately you can give away the farm. It's something that you need to be aware of for sure. So generally you have a work for hire clause in intellectual property, or you have an assignment clause, and sometimes you get both. And a lot of people know what work for hire is, or they've heard the term before, and everybody kind of says it as like a work for hire. It's a work for hire contract, but they don't actually understand legally what that term means, and it's a defined term in the Copyright Act. So really, to start out, there's an employer and there's an independent contractor setting, and which one you're in determines whether work for hire even applies or not. So a perfect example is that if you're an employee of a company, if you're an employee, you're a W-2 employee of of these consulting firms, then the big thing there is anything within the scope of your work is work for hire. And what that really means is that, to give you a layman's term, is the company sits in your position as an author. So the code that you're coding, you have no rights to, in the sense that you can't then claim ownership to it. The actual employer, if they're hiring you as an employee and it's within your scope of employment, it's their code. In an independent contractor setting, that may not be the case. And so the Copyright Act actually lays it out, some various things. So first, in an independent contractor setting, it has to be specifically commissioned. What that means is somebody has to come to you and say, I need you to do this work, right? It can't just be you're working and you happen to be an independent contractor and you came up with it, and it has to actually be commissioned. It has to be agreed in writing. So these are the big things. You have to have a contract. If there's no contract prior to you beginning work as an independent contractor, then technically it's not considered under work for hire. And so they don't just automatically get your code. And finally, it has to fall within the 9 categories enumerated in the Copyright Act. And I'm kind of building up to this and hinting at it, but let me just tell you, generally software is not within those 9 categories. It's not specifically enumerated. There's been 2 court cases where the Supreme Court has actually said that it falls within one of these 9 categories. And it was generally when, think of like a framework, when you did a piece of the code that was put into a company's already app, it was considered a collaboration or a collection of collective work, contributions to a collective work. And those are the only settings, and honestly, that court case hasn't really been followed. So in the sense of whether software can be work for hire, my opinion legally is it's really hard and really shouldn't be done in an independent contractor setting. So where does that leave us? This can bring a lot of issues up, especially if you're, let's say you're the owner of your company. You have an LLC, but you don't have an operating agreement, and you're not a W-2 employee of that LLC. You're just taking distribution. Well, then technically your LLC doesn't own your code because you're considered an independent contractor. It hasn't been specifically commissioned. It doesn't fall within the 9 categories. That can cause a lot of problems when you have multiple founders doing work on code that they're not W-2 employees. Something a lot of people aren't even aware of. Another thing is if you're an independent contractor and you actually work for a company and they don't have you under a contract, there's IRS reasons why you might not be considered an independent contractor, but there's also a lot of liability there for the company because they are not going to get your code. So the other way this is done, sorry, here you go. The real way that most people solve this problem with work for hire is they have a work for hire language in there, and then they bootstrap it with an assignment clause. The biggest problem here, and as you see the words are in bold, is that it says they're seeking to assign all work done. That can cause a whole lot of problems, especially when it's just a general, broad, very simplistic, you're assigning all rights titles to, you've seen the language, inventions, everything under the damn sun, basically. So this causes a lot of problems. Common code libraries is the biggest problem. So one of the things I deal with all the time is I represent X consultant, or I represent this consultancy firm that's dealing with a company, and they have some really form, contract, or the consultant's dealing with a company that got the contract off the internet. This happens all the time. The problem is if they have common code libraries, and I use the analogy of a person building a house. If I build a window, and my window is really nice, it's a nice bay window, and it's my signature, I make this bay window in every single house that I use, or in your guys' case, a gallery, the way you set up a gallery. However, if I want to use that in every single contract I do as I go along, or every single house that I build, well, then I can't assign all the rights to that to you individually, because what that means is you now own it, and you can prevent me from doing it anywhere else. So if you have common code libraries or forms for an attorney that you use over and over and over again, and it makes you guys more efficient at what you do, you don't have to rebuild the wheel every time you do code, this can become a problem if you're actually entering into a contract with a company that's saying you assign all the work. That's where I said you can put yourself out of business. Legally, technically, they could say, no, that code's ours. You can't do that anywhere else. Big problem. Working on multiple projects. Again, this comes into play. If you're assigning all your work to one project, well, what if you're working on another project? What if you work on one project at work, you have night, you go and work in your own little sandbox, and then you go to your Cocoa Heads meetup group, and you and a couple buddies are building a game. Well, who owns all that IP? If you're saying you've assigned all your work, and sometimes the language is broad enough that it would encompass every single scenario I just told you. And so the company you work for, or X Fortune 500 company, if you create the next Temple Run or whatever, they want to own it. They technically have rights under it under the way the contract's written. And I know this sounds ridiculous, but it's true. And the way I've seen contract after contract after contract that this is done this way. So an assignment clause, and I'll give you, this is a perfect example. I can't tell you who this came from, but this is from a real contract I just negotiated recently. Now, I'm not going to go through and read the whole thing because it'd be boring, but the real big thing here is they say, okay, you agree to any original work of authorship fixed in any tangible medium or expression which is under copyright, blah, 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 blah. They give all examples, and then they say in connection with the work, and then they say whether it's created solely with somebody else, and you'll help them assign it and do all this paperwork for it. The reason I highlighted in connection with the work is because although to an average person, in connection with the work seems like, well, yeah, this is only stuff that I'm doing on this project. Well, you tell me, I'm an attorney. Let me be a plaintiff's attorney here. Let me really think about this. In connection with the work, well, it's a software app. You're building a software app for us. That's in connection with the software app you're building over there. I mean, it can be so broadly interpreted. It's so ambiguous as to what exactly does it mean in connection with the work. This is where us attorneys get paid to really take the scalpel to this type of language. And a perfect example is in this contract, what I ultimately did was really narrow down what that language in connection with the work means. Because I didn't want any ambiguity to my client as to what is that. I only want to get assigned to you exactly the work product that I'm giving you. We work on 15 different projects. I can't just assign something loosely stated as in connection with the work. I can assign you the work product, the source code, anything that comes directly out and delivered to your hands. So this is a big thing with assignment clauses. It's something you got to think about and watch. Confidentiality, moving along. So intellectual property, now confidentiality. You guys probably see this in NDAs, but these are the major things that you really need to think about when you see any type of confidentiality clause in a contract or you're signing an NDA. And this is very, very common sense, but these things are thrown at you guys all the time. NDAs, I'm sure you guys have seen 200 NDAs. Everybody, no matter if they all think they're reinventing the wheel and they all want you to sign an NDA before they even tell you this grand idea, right? So the first question I always ask is, what am I supposed to keep secret? Because generally a lot of these confidentiality clauses or NDAs basically say you'll keep secret everything under the damn sun, blah, 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 blah. Everything we tell you is confidential information. Everything you look at, everything you smell, everything you do is confidential, and you can't tell anybody, right? No, you need to tell me exactly. You want me to keep a secret? I have no problem keeping a secret. Tell me what the damn secret is. Like, how can I keep a secret of something that I don't know what the secret is? Specifically tell me. So I say, how are we defining confidential information? I generally add mark designation language or marked language. It has to be marked confidential. Language like that's very common for me. How long must I keep this a secret for? Sometimes they want you to keep it a secret for 4 years. Sometimes it's not even put down how many years they want you to keep it a secret. You have to keep it a secret until it's in the public domain. The other problem with this is, is this really applicable? You want me to keep something confidential that you already told me we want to release this in the App Store in 3 months. Well, it's going to become public in 3 months, so why am I signing an NDA or a confidentiality agreement that puts me on the hook for 2 years? This happens all the time, guys. All right, who can I tell within my company? This is kind of nuanced and goes on. A perfect thing with this is, let's say I have campfire or something like that. A lot of times what happens is you can't tell people only on a need for no basis. So this comes up. I'm going to have to speed up because I think I only got 10 minutes. Sorry, guys. Do I need to put something in place? If you have subcontractors, you probably need to have some type of agreement with them that keeps the same type of confidentiality. Restricted covenants. What am I talking about here? Most of the time I'm talking about non-competes, but this can be non-solicitation clauses, non-disparagement clauses. So here's a typical non-compete. I agree that during the term of my employment with company, whether or not during business hours, I'll not engage in any activity that's any way competitive with the business or demonstrably anticipated business of the company. I put those up there because think about it. How can you tell what is there? I'm in the business of, apps. Any app, is my demonstrably. I can show you. I'm going to work on software apps. It's very broad language. It's things that you guys need to pare down. Some of the big things that come up here is you're balancing. A court's going to balance between your legitimate business interests versus the employee's ability to earn a living. It varies greatly between jurisdictions. In some jurisdictions, it's outlawed. And reasonableness is the key. Big things are keys. How, geographic setting, which is tough for developers because you're technically worldwide. But scope and, again, time. How long can I not compete? I put this up here because you guys want to be Boba Fett. You got Darth Vader, the company. Boba Fett is you guys. This is great. This is not what you want to be. Okay, that's what the company wants you to be with the non-compete. So warranties, and again, I'm trying to chuck through this, guys. Here's the typical warranties. Contractor agrees and warrants that the work will be accomplished in a good and work-like manner. Contractor warrants and represents he'll cooperate with the company during the whole contract. Even if they're screwing you over, you got to cooperate with them. You're warranting this. You'll agree not to disclose. This is the whole. You're not going to give us third-party confidentiality. These are common warranties that are done. The reason these come up, because this is ultimately in a termination clause, is they're saying in this termination that you can't give us defective code because you said it was in a work-like manner. And if you do give us defective code and we decide that it's defective code, well then you're required to fix it without us having to compensate with you. This is frustrating, is it not? Any software developer in here knows. I mean, Apple just released new updates. There'll be bugs. The reason they have a beta program is because they want to find out what those bugs are. But yet you'll sign a contract where they say they can do this, and they don't have to pay you for it. Well, for how long? How long does this keep going on? These are things that come up that need to be negotiated out of contracts. They need to be thought about. So, I mean, you see something like this, this is what it makes me think of. Right? I mean, ultimately, come on. One does not simply write bug-free code. Like, let's be real, guys. Indemnification. And this is, again, I got 7 minutes. I want to give you guys a couple minutes to do Q&A. It says, consultant will indemnify and hold harmless company from all claims, damages, losses, expenses, including court costs, including my fees, everything, for any action of the third party that is based on claim services. This is the whole, right here is the whole patent troll. This is saying if you give me anything, then you're indemnifying. Not only are you, if I have to go and have to, respond to a suit for patent infringement, it's on you. You guys have to pay the cost of it. So this is where this comes up. But a lot of them go even farther. They say you have to do against bodily injury, sickness, If injury or destruction to tangible personal property. The joke I always like to tell here is if your code happens to activate the Cylons, you're on the hook. So, the big things you need to think about here is you need to realize up front in everything you're indemnifying against or being indemnified for. This is negotiable. So the cost of litigation, at what time are you indemnifying them? For how much? Is there a cap on these costs? Is there not a cap on these costs? The types of claims. Is it just third-party infringement? Or is it bodily injury? Is it anything and everything? A lot of them say any and all claims based on the contract. And then the hold harmless. Can you actually sue them? So if they're at fault, the company, can you sue them as part of that? A lot of them want to include language like, no, if we're negligent, it doesn't matter. You still hold us harmless for that, right? So these are the big things you need to think about. When is the clause triggered? What must happen for the clause come into play? This is huge because a lot of times language that I tell contractors to include is say until you actually get a legal claim. Because what does a patent troll always do? It sends out a letter, cease and desist letter, and it wants you to send them money. What costs them money to actually sue that company? Well, you shouldn't have to be on the hook until it's actually a suit going on, right? If they're just hitting up the company to get money out of them, that shouldn't trigger the indemnification. Now, granted, if I'm the company, I'm not going to agree to that. But these are things that can be negotiated, tools that you can use. And then ultimately what you're trying to do is limit the coverage of the clause. So I try to put language in here like it only applies to the medium in the state that I give you the code. Because if you take my code, you change it around, you get another person to come in, and he modifies it, and then that's what's infringing on the patent, and then you get sued for it. Well, I shouldn't be on the hook, if you modify my code or you use it in a different way. Yet you can be, and a lot of them are written so you are on the hook. So this is another big thing. And then the biggest thing here is, do the warranties match the limited indemnification? If you actually negotiate out an indemnification clause and you limit it down, but your warranties are so good that they can rely on the warranties, well, then you have problems. So these are things you need to think about. If you guys have any questions, I'd love to answer them. A lot of times Q&A is better because people have specific questions. But if not, you can reach me here. I'm out of Raleigh, North Carolina, but I have clients all over the world. And you can reach me at Twitter at JD Rhyne. Go ahead.
Hello? All right. You had mentioned a clause about being bug-free or like completely flawless code.
Sure.
I've been bit by that before.
Yeah.
What recourse do I have as an
a lot of what I do, and I try to tell people this, is a lot of it's education. You have to educate your client. I have to educate attorneys on the other side a lot of times to explain to them just that. It may seem very simplistic to us, say, hey, it's all bug-free code. But the first thing you do is try to educate them and say, hey, I'll give you something that's up to the reasonable industry standards is a language I use there. Something so they know that it's not, completely perfect code, because it's just not going to happen. The other thing is you want to limit things like if there's an update. iOS 8 is coming out. Granted, when iOS 7 came out, think of how much code broke in iOS 7. You don't want to be on the hook for that if you delivered it a month before iOS 7 was announced. So generally trying to specifically limit down stuff like that is the way I do it. You try to negotiate out the language with the client. Anybody else got a question? Sure, go ahead. Go ahead, I can repeat. You said how much does it generally cost to...
Is this on? Yeah. So how much does it generally cost for you to rewrite a contract?
It depends, and that's a great question. It's kind of like a code or a contract. An app. If the app was, I don't want to say built in India, but you know what I mean. If it was an internet contract you pulled off, I'm probably going to rewrite the entire app. I have an hourly rate. It changes depending on a client because a client's ability to pay. I don't charge individual developers as much as I charge companies, and I'm very upfront with that with all my clients, so they know. But it also depends on what type of contract we're talking about, how expansive. Are we talking about a master services agreement? Are we talking about just an infinite contract? Are we talking about a joint venture agreement that's a page and a half? So not to I'm obviously dodging your question. Yeah, I'm obviously dodging your question, but I can't give you an exact amount. It changes, but I can tell you I'm pretty reasonable. I feel I'm pretty reasonable. Go ahead,
Jonathan. Thanks. Have you worked outside of the U.S. U.S. jurisdictions, and how would you work? Would you work with local lawyers in another country, or?
So this is what happens a lot with me. After AltConf, I had a couple Europeans come up to me and want me to do work. If it's general contract work, I'm okay with doing it, especially if it's contract work that's dealing with U.S. companies. I do a lot of that work. If it's something that's specific to the jurisdiction, it's very hard for me to do. I can give you, what I'm telling you here is mostly, I talked about the U.S. Copyright Act, so it was very U.S. based, but a lot of the contract terms I was talking about are dealt with internationally. And are based on English common law. It's very common too. So yes, I do the work, but I'm very careful as to not getting out of my depth. So I don't know if that answers the question, but yeah, the problem with trying to pair with an attorney is ultimately my knowledge is my value added because I know what you guys do. Obviously, you saw from this, the average attorney would never even see the issue because they don't know what you guys do. So they could be a very intelligent attorney, be very smart legally, and just not have enough information to be able to advise people. Go ahead. I think I'm out of time, but if I can keep answering questions, is that okay? It's up to you guys. I mean, okay, excellent. Go ahead, right there, I think.
I'm new to this, so I apologize if this is a obvious question.
That's fine.
You talked about how you want to be very careful that you don't inadvertently assign the rights to software that you own to the people you're doing work for. How important is it that you officially document some proof of ownership of the software that you already have and have already written, and in what form would you use to establish that?
There's two different ways that this is done generally. Like the California statute that does this, and the way a lot of forms with California companies work, is they say we own everything that you don't list out, and then they give you an exhibit and a contract and say list everything that you're claiming ownership to. The problem with that is, in my opinion, if you're a developer, that's very bad for you. It's all right, we're going to own everything other than you tell us. So if you don't tell us something, we own the code, right? Whereas I think if I'm providing a service for you, it should be very easy to write out that you only own what I'm providing to you. So I try to very much narrow it down to the work product, to what I'm actually giving you. And it's tough because, and this might be going farther into your question, but I tell a lot of my clients to not let the company have access to the source code until the end. And it's something a lot of people share updates to source code. And part of that reason is because of the whole assignment thing. So they know at the end you're getting the source code. This is what you own. This is only what you own. Come on, unless there's something else that's coming out of it, if I'm doing it, it should be my own work if it's not actually directly related to that work I'm giving you. So how you would document it, it's the same way. If you're developing code, you comment your code, right? So putting a copyright in your comment, at the top of your code is going to be documenting ownership. So you can look to it and say, oh, I committed this to GitHub on this date. It has my copyright here. This is clearly me that made this. Because the copyright's ultimately in that source code. Sure, go ahead.
So we've tried to avoid a lot of negotiation on a lot of these terms by always approaching a client and saying, early in the process, we'll send you over our draft contract.
Sure.
Which has been great, but I'm wondering if there are any risks involved in being the party that kind of presents the contract.
Okay, so there's a rule of construction in contract that generally is exclaimed in one of the miscellaneous clauses at the end of a contract, and the rule of construction is generally the benefit of the doubt goes to the party that did not draft the contract. That would be the only thing I think that could ultimately hurt you liability-wise, maybe, or maybe like a risk you have. But I think a lot of times providing the contract is what a lot of my clients I've provided. Here's a contract for you. I'll write it for you. Use it. If they want to change something, come back to me once they change something. Because especially with like that specific language with common libraries and things like that, you're not going to find this you're not going to find that language, or you're not going to find anything like that in any contract that somebody's giving out, because it's so specific to mobile applications or computer programming. So no, I don't. I actually recommend my clients do that. And from a cost-effective way, it's the most cost-effective way to deal with it, other than getting every single contract from a company and having to go to an attorney and get them to draft it out or negotiate it out. All right, I guess that's it. So thank you guys so much. It's an honor from a non-tech guy, an attorney, to be up here and talking to you guys. So thank you so much. And a lot on price, for instance, should depend on how much IP you're giving away. Is it a work for hire contract, or is this something where I'm just giving licenses out? These type of things matter, because in any contract, it's ultimately risk versus reward, and everything is negotiable down to the bare bones stuff is the Dicker terms, down to every single thing we're talking about. So to go on there, intellectual property is probably the biggest thing that's actually negotiated in a contract, or something that I think you guys should pay particular interest to because it can ultimately put you out of business. It can ultimately give away the farm. It's something that you need to be aware of for sure. So generally you have a work for hire clause in intellectual property, or you have an assignment clause, and sometimes you get both. And a lot of people in this picture, I have to start off with a Steve Jobs quote. So here we go. This is one of my favorite quotes from Steve Jobs. He says, "There's been one of my mantras, focus and simplicity. Simple can be harder than complex. You have to work hard to get your thinking clean, to make it simple." And of course, again, I told you I'm an attorney, and what does an attorney do to anything it sees? You got to mark it up a little bit, right? Yeah, so we're going to knock out thinking there and add some stuff. So really, you have to work hard to get your contract clean to make it simple. And so that's what I want to talk to you guys today about. How can we get that contract? What's being put together in front of you? What are some of the major clauses that are negotiated? And things that you guys as developers should be aware of, and even companies in this space. To start out, some of the major clauses negotiated are Dickard terms, intellectual property, confidentiality, restricted covenants, warranties, indemnification. I'm sure some of these look familiar to you guys. You guys know of them, or you've probably heard, indemnification, patent trolls, like things like that. So I wanted to take each one of these and kind of go over it and, give you guys a little bit of information about it. So Dickard terms, that's a great old English word a lot of people, don't understand. I don't really know what it really means, but what am I talking about when I say Dickard terms? I'm talking about price, I'm talking about term, I'm talking about deliverables, etc. These are the things like, is it an hourly contract? Is it a milestones contract? These are things that are commonly everybody thinks about that are actually negotiated in the contract, but things that you guys should pay close attention to because depending on, how the contract is set up, should depend.
Say hello a lot of times. So if you missed it before, we will have thumb drives over at Labs all afternoon with betas of all the cool new stuff we just saw. And also, anybody in a blue shirt can help you if for any reason you feel unsafe or anything weird is going on. Just find somebody. I'd like to introduce you to our next speaker. He is an iOS dev attorney from Raleigh, North Carolina. He is a tech enthusiast. He loves soccer, the Arsenal specifically. May I present Jonathan Rhyne.
Hey, how you guys doing? Can everybody hear me? Yep. All right, awesome. Well, as you guys know, they decided to put an attorney up here in front of you guys first instead of anything else. So I thought I would start out with a nice little programmer joke. All right, how many software developers does it take to screw in a light bulb? None. That's a hardware problem. All right, so I'm Jonathan Rhyne. As she said, I'm an iOS dev attorney. I've been doing this for about 5 years. I represent individual developers as well as some of the bigger companies. You guys probably know a couple of my clients, and you probably don't know some of my clients. So after AltConf, I gave a talk there. I realized that I have to start off every talk with an obligatory Steve Jobs picture. So we'll start off. My name of the talk is Debugging the Contract. And there's my obligatory Steve Jobs picture. Yay! All right, and then also I learned after AltConf that as well as starting my talk off with the obligatory Steve Jobs